Hello and welcome. This is a new court filing from the Karen Reed defense team. It was submitted yesterday, January 23rd, 2025. Today is January 24. The document reads, Defendant Karen Reed's motion to recover expert-related expenses from the Commonwealth. Now comes the defendant, Karen Reed, in parentheses, quote, Miss Reed, end quote, and respectfully moves this honorable court to order that the travel costs and related expenses associated with defense expert Matthew Erickson's December 2024 trip to Massachusetts be paid for by the Commonwealth. Those costs, which include travel expenses, lodging, and other accommodations, and expert fees associated with the trip to the Canton Police Department, were incurred after the Commonwealth agreed to allow Mr. Erickson to visit the Canton Police Department, in parentheses, quote, CPD, end quote, so that he could perform an independent analysis of the CPD ExactQ Vision DVR system and any video footage it contained from January 29, 2022 between 12 a.m. and 11:59 p.m. When Mr. Erickson arrived at the Canton Police Department, all original DVR footage from the relevant date had been destroyed, at best due to improper preservation by the Commonwealth. Because the Commonwealth failed to preserve the original video evidence, Mr. Erickson's trip to Massachusetts was futile. The costs associated with his travel to the Canton Police Department would not have been incurred but for the Commonwealth's representations that the evidence existed, and that Mr. Erickson would be able to obtain an original copy of the video surveillance footage at issue. Accordingly, in the interests of justice, this court should order that the Commonwealth, not Miss Reed, pay the cost of having her expert travel out of state to obtain a copy of the video surveillance footage, which the Canton Police Department, in parentheses, an agent of the Commonwealth, failed to adequately preserve. Really good argument so far. Their initial ask of this court is, to me, reasonable so far. They were informed by the Commonwealth that the Commonwealth had footage of the DVR system from January 29, 2022 between 12 a.m. and 11:59 p.m. And if you guys remember the evidence, Karen Reed arrived at John O'Keefe's house at 12:28 a.m. And according to Trooper Joe Paul, the alleged accident occurred at 12:45 a.m. So Karen Reed was already at John O'Keefe's house before the official narrative said that Karen Reed struck John O'Keefe with her vehicle. So the defense team brought on an expert to analyze the DVR system, and the Commonwealth somehow destroyed all that footage, all that evidence. Okay, guys? So this is an accumulation of red flags, right? Somehow there are no security camera footage, door camera footage, ring camera footage from anyone's house proving that Karen Reed did this, right? And there is no camera footage from anyone's house showing the condition of Karen Reed's taillight after she supposedly did this, right? And on top of that, guys, on top of that, the Commonwealth did not preserve the footage that was in Canton Police's possession. The Commonwealth did not preserve the Canton Police Department footage. You see, guys, and I've said it in multiple videos, there were multiple Brady violations committed against Karen Reed in this case. Multiple Brady violations. And if you guys don't know what a Brady violation is, it's when the other side withholds evidence that could exonerate the accused. Okay? There were multiple instances in this case in which the Commonwealth, in which those who want to prosecute Karen Reed withheld or destroyed evidence or manipulated evidence, right? Remember the Sallyport footage that was flipped? Remember that too? Multiple red flags here, guys. All right? It's more conceivable at this point. If you are using logic and reason, it's far more conceivable at this point to state confidently that this is a cover-up in which multiple Brady violations were committed against Karen Reed. Continuing with the motion. Factual background. Miss Reed is accused of the following crimes arising out of the death of Officer John O'Keefe. Murder in the second degree in violation of MGL. We already know all these charges. I'll just skip ahead. In preparation for trial, the defense requested access to the Canton Police Department, CPD, DVR system, and drives that hold recordings from the CPD security camera system so that defense expert Mr. Erickson could obtain video files in their native file format with all available metadata. Sorry. From January 29, 2022, between 12 a.m. and 11:59 p.m., in order to ensure the accuracy and a complete download of all available data and metadata, the defense requested that their expert be allowed to make a mirror image of the DVR system's drive. This video footage is of critical importance to the defense. The Commonwealth has provided the defense with CPD video footage on 3 occasions. On April 4, 2024, shortly before the first trial in this matter. I'm going to read the footnote, though, before sorry. I'm going to read this footnote. So right here in the sentence up here, it reads, the Commonwealth has provided the defense with CPD video footage on 3 occasions. And right here is the number 2. So we're going to go down to number 2. Notably, when Mr. Erickson arrived at the CPD to extract video from the DVR system, the security camera system was set to overwrite older video surveillance footage with new video surveillance footage after approximately 30 days. Notably, however, each of the 3 instances in which the Commonwealth produced CPD footage to the defense was far outside the 30-day, I'm going to scroll down here, 30-day window after which the CPD DVR system was set to overwrite older video recordings. See infra pages 5 to 7. Thus, an agent of the Commonwealth must have saved all of the aforementioned footage in playable format at some point before the end of the 30-day period, which ended in February 2022. The Commonwealth therefore had care, custody, and control of all of the footage produced to date during the discovery phase of the initial trial and chose not to turn it over to defense in a timely manner. Again, guys, Brady violation. Brady violation. They had footage from around that time, and the footage that they had, that they did provide to the defense team, wasn't enough to say Karen Reed did or did not do this, right? Conveniently, the footage that the CPD did provide to the defense team and that the Commonwealth did provide to the defense team is still ambiguous. It does not prove or disprove much, at least in the defense of Karen Reed, right? It's like footage, it's footage that kind of leaves everything in the air. And remember, the Sallyport video itself was flipped, right? So it's like they didn't provide all the footage, and the footage that they did provide to the defense team was either manipulated or didn't provide enough information to say what was going on. Right, guys? Like, they withheld the footage that could exonerate Karen Reed. That's what it sounds like to me, and that's what it looks like to me. If they have withheld so much else in this case, right? More than likely, they withheld the footage that exonerates Karen Reed. Continuing with the motion. On April 4, 2024, shortly before the first trial in this matter, the Commonwealth produced footage from the CPD main driveway and CBD Sallyport front wall for the very first time. Provides an attachment. The Sallyport front wall footage provided by the Commonwealth omitted a 42-minute interval during which the SUV arrived at the CPD Sallyport garage. You see, guys, it omitted a 42-minute interval. It's missing. 42 minutes of that footage from the Sallyport is missing. Continuing with the motion. Trial transcript. It's an attachment, sorry. Continuing with the next sentence. This missing footage could have been used to show the condition of the SUV's right taillight upon arrival at the Sallyport, and to date would be the only footage that serves this purpose. Provides an attachment. The condition of the right near taillight of the Lexus SUV at the time it entered law enforcement custody is perhaps one of the most critical and highly contested issues in this case. Mid-trial on April 23, 2024, via a share link entitled, quote, additional Sallyport video download link, end quote, the Commonwealth produced additional footage from the CPD Sallyport back wall. And this is stupid. This is just me. But the word entitled is a typo. It should just be titled. Entitled only refers to like one's right, one's possession. Anyway, sorry. Continuing. Quote, additional Sallyport video download link, end quote. The Commonwealth produced additional footage from the CPD Sallyport back wall. At trial, Trooper Yuri Buchanan testified on direct examination that the footage of Miss Reed's vehicle from this interior Sallyport camera was an accurate depiction of the Sallyport and the SUV, and that, as seen in the video, no law enforcement officer approached the right rear taillight. And it provides an attachment of the trial transcript. It continues. On cross-examination, however, it became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality, despite neither the Commonwealth nor Trooper Buchanan having mentioned it on direct examination. Right, guys? Just a complete violation of justice here, right? Like, they are presenting it in a manner that is misleading. It's manipulative. It's abuse of the system. Continuing. Provides an attachment of the trial transcript. It continues, therefore, when the video appeared to show a person standing near the left rear taillight of the vehicle, in actuality, the person was in fact standing near the right rear taillight, in parentheses, i.e., the taillight at issue. Yes. Yes, they inverted the freaking video, guys, to make it seem like they were on the left rear taillight, when they were actually at the right rear taillight. They had plenty of time to manipulate, to destroy the right rear taillight. To then what, guys? If you remember the Microdots video from just the other day, to what? To go back to 34 Fairview and plant some broken taillights, right? That they obtained at the Sallyport after breaking apart Karen Reed's rear right taillight, right? It's so crazy, guys. It's almost like they couldn't decide which footage to destroy, which footage to hide. And they're like, oh man, do we really have to show them the Sallyport footage? Because it's going to show us fucking with her taillight. And then someone was like, dude, just flip the video. Just flip the video. They won't know the difference. Just flip the video. They'll think we were on the left taillight. Problem solved, right? They'll never fucking notice, will they? These are fucking snakes, guys. And they are all in law enforcement. Snakes in uniform, fucking with people's lives, people's fate. And remember, John O'Keefe was an officer, okay? This is how his fellow officers do him, you know? This was how his fellow officers in other police departments, this was how they treated his death. By not investigating it and by instead planting evidence to help their other officer friends, the Alberts, right? Okay, sorry if I'm yelling in your ear. Continuing with the motion, it provides an attachment to the trial transcript. It continues. It remains unclear why this inverted video was withheld by the Commonwealth and produced to the defense in the middle of trial after the initial CPD surveillance footage was turned over by the Commonwealth. Remember that, guys, pulling away from the motion. Remember, discovery is supposed to be completed and concluded before trial begins. But this was yet another instance in which the prosecution withheld evidence and they gave it to the defense team reluctantly after the trial had already begun, right? So that the defense is running around with their heads cut off, right? Like, oh my gosh, like we gotta argue this now. We gotta present this now. It's so fucking chaotic, and it's on purpose thanks to the Commonwealth. You know, it's a way to sabotage the defense's strategy by giving them evidence in the middle of fucking trial. Continuing. Okay, sorry, continuing. Most recently, post-trial on October 10, 2024, the Commonwealth again provided new video surveillance footage, this time from the CPD church side exterior. First floor corridor, rear lot main side, and rear lot cruiser side angles. It provides an attachment. This footage shows Brian Higgins arrive in the parking lot of the Canton Police Department at 1:26 a.m., enter the Canton Police Department, and speak to some unidentified individuals on the phone as he is leaving the Canton Police Department between 1:34:52 and 1:34:56 a.m. Significantly, this material and relevant evidence, which establishes Brian Higgins was on the phone with some unidentified individual at 1:34 a.m. as he left the Canton Police Department shortly after O'Keefe's death, was withheld from the defense at the first trial. Yeah, more withholding of information, of evidence from the prosecution. Continuing, the video surveillance footage at issue was a major point of contention at trial, in no small part because the Commonwealth was utterly unable to establish any chain of custody for the various clips of video produced to the defense from the CPD. The footage produced by the Commonwealth is rife with issues that call into question its accuracy and forensic viability, including the presence of the inverted video and the large-scale gap missing from the feed at the precise time at which Miss Reed's Lexus should have been shown entering the CPD Sallyport garage. In spite of the fact that the Commonwealth claims the video surveillance feed is motion activated. Yeah, pulling away, exactly. Guys, like, how can that many videos malfunction? How can that many cameras not work? The cameras from the neighbors, the camera from, what is it? The neighbor across the street from 34 Fairview, Kelleher, his camera wasn't working. None of the cameras at any other houses were working. Not a single damn camera between 34 Fairview and John O'Keefe's house at One Meadows. You know, Karen Reed arrived at John O'Keefe's house, remember? And it was before the time Trooper Joe Paul said she struck John O'Keefe, right? Karen Reed's cell phone connected to John O'Keefe's Wi-Fi, right? So we all know that Karen Reed left 34 Fairview and she arrived at John O'Keefe's house. And it's like a 10-minute drive. I'm not really recalling exactly, but it's not 20 minutes. Certainly not 20 minutes. And between that time frame, she passed through roads, she passed through neighborhoods, she passed by multiple houses and multiple businesses and even a public library. And nowhere in any of those locations was a camera recovered showing Karen Reed's rear right taillight. And on top of that, the Sallyport cameras themselves do not show Karen Reed's rear right taillight before it is broken, as it's arriving. You guys see? Just like, how can that many cameras fuck up in one night? How can that many CCTV footage devices fuck up in one night? Coincidence or cover-up? I also want to highlight that this part where it reads, in spite of the fact that the Commonwealth claims the video surveillance feed is motion activated. If it's motion activated, why didn't it capture Karen Reed's Lexus? Why didn't it capture that right rear taillight before the officers fucked with it? Right? We only see the aftermath, guys. That's what I'm saying over and over again. All of the evidence the Commonwealth, the prosecution, has provided, all of it does not show what Karen Reed's taillight looked like before they fucked with it. Not one piece of evidence proves what her right rear taillight looked like before they fucked with it in the Sallyport. And one more thing before I keep reading. The chain of custody. The Commonwealth was utterly unable to establish any chain of custody for the various clips of video produced. Isn't that crazy? They couldn't provide a chain of custody for the evidence. They couldn't provide a chain of custody for the evidence they half-assed collected at the scene at 34 Fairview, right? Like, this is John O'Keefe's life. This is John O'Keefe's legacy, right? And they did a botched job and zero chain of custody when it came to all of that evidence, all of the forensic evidence. Not only was there no investigation, There is also no provable chain of custody for the forensic evidence. And on top of that, there is no chain of custody for the video footage, guys. This would all be laughable if it wasn't so corrupt and angering and enraging. And they really want to swear that it's not a cover-up. They really want to swear that they did the best they could. Like the Commonwealth, like Adam Lally, Michael Morrissey, Hank Brennan, all those dicks, they really think that they have a case, despite being sloppy as hell. Just all of them like insulting our intelligence, all of them assuming we are all idiots. I made a video about Michael Morrissey, and I said he thinks we are all idiots, and I still stand behind that statement. The fucking prosecution in Norfolk County thinks the public is made up of idiots. Continuing with the motion. The fact that the Canton Police Department produced video surveillance with an inverted video and a gap in the footage at the critical moment, in parentheses, i.e., at the precise time Miss Reed's SUV arrived at the CPD garage, end of parentheses, is not trivial. It goes to the heart of Miss Reed's defense. Yes, it does. It's not minor, guys. It's fucking critical. It's crucial. Continuing. In response to the defense's request, Special Assistant District Attorney Hank Brennan agreed to allow defense access to this critical information and to make the arrangements necessary for Mr. Erickson to extract video from the DVR system. Accordingly, Mr. Erickson traveled from Phoenix, Arizona to Boston, Massachusetts on December 11, 2024, and after making the arranged visit to the Canton Police Department, returned to Phoenix on December 12, 2024. Crazy, guys. What the fuck? You guys know how far it is from Massachusetts to Arizona? I know because I make a trip out there almost every year. I used to live in Arizona and I still have family out there. Yeah, you know how long it is, guys? It's over 2,000 miles. It's like 2,400 or so miles from Massachusetts to Arizona. Okay? And a plane ride with that distance is 6 to 8 hours, depending, right? So this dude flew from Arizona to Massachusetts on one day, and then he flew from Massachusetts to Arizona the immediate next day. Crazy. Like not only is this coming out of Karen Reed's pocket, it's also Mr. Erickson's time, you know? Like, how fucking dare the Commonwealth, you know? Like, it's not like he was in New York or in Pennsylvania, you know? Like, he was all the way to fucking Arizona, guys. Just the Commonwealth, they've got so much bad karma coming to them. OMG. All right, continuing. The work Mr. Erickson did in connection with this trip, as well as the flights, hotel stay, Uber rides, and other accommodations associated with his travel to Massachusetts, cost Miss Reed a total of $12,229.57, and they provide the affidavit from the expert, from Matthew Erickson, in the attachment. $12,000, guys. This guy had a one-day visit from Arizona to Massachusetts, and he had to turn the fuck around and fly back, and it cost Karen Reed over $12,000. Like, the Commonwealth is fucking with people's lives over and over again. They're fucking over John O'Keefe. They're fucking over Karen Reed. They're fucking over Aidan Kearney. And they're fucking over all these experts. Even the fact that they made Dr. Marie Russell come back, and she lives in California. They made her ass fly back here for the unnecessary Daubert hearing that Judge Beverly Cannoni agreed to have her on anyway, for the retrial anyway. Just, and I've said it before, guys, this is economic abuse against Karen Read. There ought to be like some kind of financial abuse clause in cases like this. You know, that if you fuck up a case and you can't even provide a chain of custody for your evidence or for your surveillance system, you know, that it's provable that this is a cover-up. It's provable that there are multiple Brady violations here. Then the Commonwealth should have to pay for everything, not just Erickson's cost, not just Karen Read's cost, you know? Like, this is all financial abuse. And I've said it in previous videos. Like, imagine if Karen Read was poor. Imagine if Karen Read couldn't afford to defend herself, or she didn't have the following that she has right now. And granted, a lot of content creators and social media influencers have assisted in raising Karen Read's defense team, especially Aiden Kearney. But imagine if none of that was happening right now, guys. Again, think about all the cases we are not hearing about. Think about all of the cover-ups we are not hearing about because those people don't have money like this. It's financial abuse. It's an attempt to empty Karen Read's pockets so that she submits, so that she gives up, right? It's part of the agenda. It's infuriating. It's enraging. Continuing with the motion. As planned, Mr. Erickson visited the CPD on the morning of December 12, 2024, to extract video from the DVR system. He arrived around 9 a.m. and was met by Colleen Crawford, a multimedia director and certified forensic video technician from the Norfolk District Attorney's Office, as well as 3 others. Miss Crawford expressed surprise that Mr. Erickson was there to extract video from the DVR and, relatedly, skepticism that the footage would still exist. Mr. Erickson subsequently asked whether anyone had accessed the system to determine whether the relevant video footage was even present. They answered, quote, no, end quote. Notably, before Mr. Erickson made this trip to Massachusetts, counsel for the defense team spoke directly with Miss Crawford, who was made aware of the footage the parties had agreed would be extracted by the defense. Continuing with the motion. After photographing the relevant equipment, Mr. Erickson began recording and then accessed the system. Initially, it appeared to him that there were only 30 days of video history and, consequently, that the relevant footage had not been preserved. That impression was confirmed when he navigated to the appropriate section of the DVR system where a search by day and time could be performed, and ran a search for January 29, 2022 between 12 a.m. and 11:59 p.m. The search returned 0 results based on the size of the drives, the percent usage, and the remaining usable drive space. Mr. Erickson concluded that there was mathematically no possible way for the videos from January 29, 2022 to be present in December of 2024 when he performed this search, unless they were manually saved and or properly preserved via standard forensic protocols. Again, this was pulling away from the motion. Guys, this was a Boston police officer. John O'Keefe was a Boston police officer, and Canton PD didn't give a fuck about him. They didn't even give a damn about preserving the video footage. And you have to ask the question, why? Continuing. Next, Mr. Erickson began the process of generating any activity logs for the date of interest. This request ran for an abnormal amount of time without showing results. When asked whether the system had ever behaved this way and whether it could be expected to complete the request, the person on site who was most familiar with the system shrugged and said he didn't know. After investing approximately 10 minutes into this and similar actions with no results, Mr. Erickson determined that the relevant activity logs were also gone. So, no pulling away from the motion, no video footage from the time in question from January 2022, no video footage, and no activity logs. Like whose decision was it really to fuck Karen Read over? You know, ultimately, who at the top has the most power? It's Michael Morrissey. And who at the top keeps pushing this case despite all the lawyers who are watching it closely, despite the ACLU watching it closely, despite the world of audience members watching it closely? Who has the most power? Michael Morrissey. Right? And next to Michael Morrissey is Judge Bev. She's the judge. And we've all seen her corruption too. No chain of custody for any of the evidence. No chain of custody for any of the video footage, and no activity logs. And we know that Michael Morrissey isn't prosecuting the Canton Police Department. We know that Michael Morrissey isn't looking at this case and saying, well, you know, no chain of custody for anything. Just throw it out. We're not going to prosecute Karen Read. No fucking way. We got other important cases to prosecute. Michael Morrissey isn't doing that. He clearly wants Karen Read to go down for this. He clearly wants it to just go away, despite all of the evidence pointing at her being innocent. And despite all of the evidence that could put her away being non-existent. Right? There is more evidence that Karen Read didn't do this than there is anything saying she did. In fact, there is zero evidence saying that Karen Read did this, and Michael Morrissey knows it. As a district attorney, Michael Morrissey knows it. But you see how he persists. You see how the Norfolk County in Massachusetts, the Norfolk County DA's office, you see how it persists. Despite all those prosecutors turning down this case, Adam Lally being the only pushover to take it on, and they had to hire from outside the DA's office. They had to bring on Hank Brennan. Hank Brennan and Adam Lally doing the dirty deeds for Michael Morrissey on a case that a majority of people observing and witnessing believe is a cover-up. Just a waste of energy, a waste of money, a waste of resources, a waste of taxpayer dollars, a waste of all of these experts' time. Again, Erickson, making a 48-hour trip from Arizona to Massachusetts, from Massachusetts back to Arizona. This is excessive, guys. And again, if it is happening to Karen Read, someone with resources, you best believe it is happening to multiple other victims in the state of Massachusetts and everywhere else in this country. And I'm not saying every district attorney's office is corrupt, but I am saying we aren't hearing about all the cases in which victims are suffering like this, like Karen Read has. We are not hearing about all those cases. Not every case becomes a high-profile case. So it's something to think about. You know, again, why does the U.S. have the largest prison system, the largest prison population in the world to date? Continuing. Mr. Erickson asked the individuals whether they had done a forensic extraction of the drives to get the original data, to which they answered, quote, no, end quote. He asked how they preserved video when they needed to, and they responded that they simply manually saved the video from the DVR. Finally, he asked if they had a written protocol in January 2022 or now for saving video. They responded that they did not. Okay, so, right, like just some police department in Canton, just some random police department not doing their job and not having a protocol for saving video footage that could prove or disprove cases. Right? No fucking protocol. Like, there's no oversight at the Canton PD. And I told you guys in previous videos, I used to be in public transportation. I used to have to review security footage. I used to have to review CCTV footage. Okay, I was responsible for over 400 drivers. I was also a safety trainer, a road supervisor. And I had to review footage all the damn time to do my job. And we had protocols. And we're not even law enforcement. We're not even law enforcement, guys. And we had protocols for saving videos, for extracting video footage and saving it. You know, and we had to document everything. You know, there was a log for literally everything. And this police department, which is supposed to have more authority than a road supervisor or a safety trainer, a police department, doesn't have protocols for saving video. It's like they either do have protocols and they didn't use them because they knew it was fair for Karen Read, or they really don't have protocols. And if they don't have protocols, guys, everyone in Canton should be afraid for their life. Everyone in Canton should demand more of the Canton PD if they don't got protocols for saving video that can prove or disprove cases. It's the Twilight Zone. It's the fucking Twilight Zone, guys. Continuing. The individual refused to provide Mr. Erickson with a copy of the original video files that they pulled from the DVR system, stating that it had already been provided to defense counsel. When asked how they produced the footage to the court and or the defense, they looked confused. Mr. Erickson clarified by asking whether it was provided on a USB drive, disk, or share link. They could not tell him for sure, but eventually said it was probably a share link. The way CPD technicians extracted the video data from their DVR system is insufficient for forensic purposes and has resulted in the permanent loss of the original surveillance video data. The CPD DVR system, like most, stores videos in a proprietary format. CPD uses the DVR interface to pick and choose which videos to save, and then that data is converted by the system into a playable format. The resulting file is almost always of lesser quality than the original, and because it exists in a different format, the resulting file will not hash verify to the original. As such, forensic experts cannot properly test the authenticity and integrity of the video footage. You see, guys, it's lost. It is lost evidence. Again, how many things can go wrong in one case? How many things can go wrong in one damn investigation? That's right. There was no investigation. There was never an investigation into the death of John O'Keefe. There was never an investigation. Continuing. Due to the Commonwealth's failure to preserve the original surveillance footage, Mr. Erickson was unable to extract video from the DVR system footage from January 29, 2022 to obtain relevant footage between 12 a.m. and 11:59 p.m. as previously arranged and agreed upon by all parties. Thus, the Commonwealth's failure to adequately preserve evidence has resulted in the destruction of 1. A forensically sound image or hash-verified copies of the video surveillance footage from CPD on January 29, 2022, and 2. Logs establishing the individual who accessed, manipulated, copied, and or deleted the footage from January 29, 2022 from the CPD DVR system. Mr. Erickson left only with the audio and video recording of his work and photographs that he captured from the DVR menus, which demonstrate that the Canton Police Department and Norfolk County District Attorney's Office failed to preserve all video surveillance footage and associated logs, both of which are material and relevant to this case. Pulling away from the motion, like if I were the Norfolk County District Attorney's Office or the Canton Police Department, I would feel like a fucking slob. I would feel like a slacker. Like I shouldn't be in law enforcement, or I shouldn't be in law. I shouldn't be a prosecutor because I don't have my shit together. Right? Like they don't have their shit together. And they have no information that, again, can prove or disprove their allegations against Karen Read. They have no evidence to prove or disprove their allegations against Karen Read. Not one chain of custody. They have a crooked timeline that they botched themselves. And I'll keep saying it because, again, Karen Read connected to John O'Keefe's Wi-Fi. And they remembered that. Trooper Guarino remembered that. He was able to state that during the trial. But Trooper Joe Paul didn't connect the dots. And while Trooper Joe Paul was saying Karen Read backed into John O'Keefe, Karen Read was already at John O'Keefe's house at One Meadows. So they have a botched timeline, zero chain of custody, whether referencing the forensic evidence or the video footage. And the so-called evidence they do have is all over the damn place. It's all over the damn place, guys. Like, this is how the Canton PD solves cases. This is how the Norfolk County DA's office solves cases. Again, people in Norfolk County should be livid. They should be demanding that their tax dollars go to a better use than to funding this corruption. Continuing. Letter I, argument. The Commonwealth had an obligation to preserve the original DVR surveillance footage from January 29, 2022. In Massachusetts, quote, the Commonwealth has a duty to preserve exculpatory evidence for the defendant to inspect, examine, or perform tests on, end quote. Commonwealth versus Harwood provides the case law. And in parentheses, citing Commonwealth versus Woodward, state courts, quote, have repeatedly stressed the need for prosecutors to do their utmost to preserve and present exculpatory evidence which is available to the prosecution, end quote. And pulling away, guys, because if they don't, then they are committing Brady violations. Continuing. Evidence is considered exculpatory if it merely, quote, tends to diminish a defendant's culpability, end quote, provides a case law. Any evidence which, quote, tends to impeach the credibility of a key prosecution witness, end quote, such as evidence showing that footage of the defendant's vehicle, the alleged murder weapon, has been tampered with or altered, quote, is clearly exculpatory, end quote. Really good structuring here by the defense team. And so that was a Roman numeral. The first one, this is Roman numeral 2. It reads, for the loss of the original DVR surveillance footage, Miss Reed is entitled, at minimum, to recovery of expert-related expenses, quote, when potentially exculpatory evidence is lost or destroyed, end quote, as here, quote, a balancing test is employed to determine the appropriateness and extent of remedial action. The courts must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant, end quote, provides case law. And another case law. Here, the balancing test indicates that the Commonwealth is culpable for the loss of the original footage. The footage was material evidence, and its loss prejudiced Miss Reed. Letter A. The Commonwealth is culpable for the loss of the original DVR footage. Critically, the purpose of this balancing test Critically, for the purposes of this balancing test, the Commonwealth is culpable for the conduct of its agents. And, quote, culpable, end quote, conduct includes actions ranging from intentional to negligent and inadvertent. Provides case law. Citation. Therefore, the failure of Canton Police Department to preserve the footage, whether intentional, reckless, negligent, or inadvertent, is attributable to the Commonwealth. Provides another citation for the same case law. In parentheses, quote, the prosecutor's obligation for proper handling of exculpatory evidence extend to material in the possession or control of members of the prosecutor's staff and any others who have participated in the investigation or evaluation of the case and who either regularly report or with reference to the particular case have reported to his office, end quote. And it's quoting from the case law they cited. And that's really good, really compelling case law to refer to. That it's actually in case law, that it's supporting their argument, that it's absolutely the prosecutor's obligation. Continuing. Here, the Canton Police Department was in possession of the footage, knew that it was potentially exculpatory before it was lost, and failed to preserve it. Relevant members of the Norfolk County District Attorney's Office also failed to take steps to have the data preserved. 1000%. And it cites the case law, in parentheses, upholding lower court decision that, quote, the Commonwealth was responsible for the inadvertent loss of the evidence and was culpable for its failure to preserve exculpatory evidence, end quote, given, quote, the failure of the Assistant Attorney General to be sure that the file was preserved and the negligence on the part of the allegedly defrauded company, which was working with the prosecution, in misplacing the file, end quote. B. The original DVR footage was material. Quote, evidence is material if, in considering the entire record, it creates a reasonable doubt as to the defendant's guilt that would not otherwise exist, end quote, provides the case law. In parentheses, reasoning that the Commonwealth's failure to preserve the original letter prejudiced the defendant because the original was necessary to know whether the signature was forged, and because it was not, quote, the Commonwealth's principal witness may be impeached and the defendant's case substantially advanced, end quote. Really good case law they are citing, guys. Continuing. Here, the relevant video evidence speaks to the state of Miss Reed's vehicle immediately after John O'Keefe's death, as well as the handling of that vehicle by CPD, both of which are key issues in this case. In some cases, it is important for the Commonwealth to maintain and preserve the original piece of evidence rather than a copy. Compare Hardwood case law. In parentheses, finding that loss of original letter prejudiced defendant because defense expert could not determine authorship based on photocopy where authorship was relevant to fraud claim. End of parentheses. And in another case law, in parentheses, finding that loss of original paper bag with handwriting found at homicide scene did not prejudice defendant because handwriting expert stated the photograph of the bag was adequate for his analysis and testimony was based on the photograph, which defendant had access to. In end of parentheses. It continues, this is one such case. First, the original DVR data and footage was necessary for proper analysis of the authenticity and integrity of the video, both of which are actually at issue here. That is especially concerning in this case where there is substantial evidence suggesting that the videos have in fact been altered despite claims to the contrary by the Commonwealth and its agents. Second, because of the methods used by CPD to access a playable format of the surveillance footage, the videos ultimately produced by the Commonwealth are of lesser quality than the original footage. For these reasons, the fact that the videos are available in some form is not sufficient. The videos in their original format were material and should have been preserved. Absolutely. Really good structuring of this motion by the defense team. Absolutely. They are hitting multiple points here. Multiple points, guys. Continuing. Letter C. The loss of the original DVR footage prejudices Miss Reed. As detailed above, there is significant evidence that the DVR footage provided to defense and shown at trial was altered. The fact that the original DVR footage is now permanently unavailable hinders Miss Reed's ability to demonstrate the differences between the original footage and the footage provided to defense and shown at trial. Differences suggesting the footage was tampered with or otherwise altered, and deprives her of critical evidence about how those differences came to be. Continuing, and it cites a case law. In parentheses, defendant was not prejudiced by loss of original bloody fingerprint, where both experts testified that inconsistencies between the original and photograph could be identified and fully explained without the original by the different conditions under which each print was obtained, and where no evidence suggested the blood contained in the original could be used for DNA testing. Ultimately, the loss of this evidence in its original format, which resulted directly from the actions and inactions of the Commonwealth and its agents, hinders Miss Reed's ability to put on an adequate defense. Again, really good wording, really good structuring of this motion. Continuing, the loss of the DVR footage in combination with the Commonwealth's misrepresentations further prejudices Miss Reed by burdening her with a significant and unnecessary financial expense. The Commonwealth, by agreeing to and arranging the CPD visit, led Miss Reed and her team to believe that the relevant footage existed and that the defense's forensic expert would be able to forensically extract the relevant footage if he flew to Massachusetts to visit CPD. Because of the Commonwealth's representations, defense expert Mr. Erickson did fly from Arizona to Massachusetts, stayed overnight in a hotel, and traveled to Canton Police Department for the agreed-upon imaging. Yet, he was never able to perform the imaging as the Commonwealth had failed to preserve the information. The Commonwealth failed to take any steps to determine whether the footage still existed before prompting the defense to send its expert to Massachusetts, despite an apparent understanding by CPD technicians that such footage did not exist. For the services rendered on December 12, 2024, and associated travel costs, Miss Reed paid defense expert Mr. Erickson's employer, USA Forensic LLC, a total of $12,229.57. This expense is significant and draws on the financial resources needed by Miss Reed to defend herself at trial in this matter. Absolutely. Again, really logical, really reasonable, and I contend, again, that this is financial abuse committed against Karen Reed. It's a perpetual strategy of financially abusing Karen Reed so that she runs out of money. It's as if that's the Commonwealth's plan to empty Karen Reed's bank account so that she runs out of money and she gives up. Continuing, letter D, the appropriate remedy for the loss of this evidence is, at minimum, recovery of these expert-related expenses from the Commonwealth. Given the materiality of the lost evidence, the prejudice to Miss Reed, and the culpability of the Commonwealth, Miss Reed is entitled to a remedy. There is no particular remedy for the loss of evidence. Instead, quote, our courts have fashioned or upheld various judicial remedies, from allowing the defendant to bring to the jury's attention the Commonwealth's negligent handling of the evidence to dismissal of the indictment, end quote. Really, really good. Pulling away. It's like the defense is like, we'll put the Commonwealth on blast. We'll put the Commonwealth on the stage, and we'll show the jury members how the Commonwealth fucked up. The Commonwealth wanted to bring this case so badly against Karen Reed But look at the lack of chain of custody. Look at how they did not preserve evidence. Look at how they didn't give a damn about the cross-contamination when it came to the forensic evidence on scene, right? Just multiple failures from the Commonwealth, you know? Okay, continuing. These decisions are within the sound discretion of the trial judge and are reviewed for abuse of discretion, provides the case law. Because the travel expenses and expert fees associated with this trip were the direct result of the Commonwealth's representations to defense, and because the Commonwealth's failure to fulfill its obligation of preserving the video made the defense expert's trip to Massachusetts futile, Miss Reed is entitled, at minimum, to recover these costs from the Commonwealth. Ooh, yeah, pulling away, guys. Really strong arguments. Just, they're like punching, left, right. Just really solid arguments that, to me, Judge Bev has got very little wiggle room here. Very little wiggle room. There's like a civil aspect to this as well. There's like a clause, something about money. I'm trying to remember it right now. But it's like, if you, I'm forgetting the official term in civil cases, but, like reliance. It's like something like monetary reliance, or anyway, it's like when you put someone in a position because of how you presented something, they are entitled to be recompensed, to be made whole because of what you presented. Like, it's just like what the Commonwealth did to Karen Reed. The Commonwealth said, yeah, bring your expert from Arizona over here. We'll arrange it with the Canton PD. The footage is all there. Just bring your expert. Have them come on over, right? And then there ain't shit there for him to analyze. There's nothing there for Mr. Erickson to analyze, to investigate. So it was the Commonwealth's responsibility. It was their obligation to make sure that Mr. Erickson's trip wasn't going to be needless. It wasn't going to be proven all for naught. To me, the defense has a strong civil lawsuit against the Commonwealth, even if Judge Bev doesn't grant this motion. And guys, if she doesn't grant this motion, oh, yeah. I was surprised that she allowed Dr. Marie Russell to testify again for the retrial. I was, and I do intend to do a part 10. I have not forgotten, but so much information has come through since then, since the Daubert hearing. It's all coming in rather quickly, like this motion. It came in just yesterday. So who knows is what I'm saying. If Judge Bev is okay with letting Dr. Marie Russell testify at the retrial, who knows? She might grant this motion too. Anyway, continuing with the motion, number 3, allowing Miss Reed to recover these expert-related expenses from the Commonwealth is in the interests of justice. Miss Reed is not indigent and therefore would typically be responsible for her own expert costs and fees. Provides a Rule of Criminal Procedure 17, in parentheses, providing for coverage of an indigent defendant's witness expenses by the Commonwealth, but not for coverage of such expenses for non-indigent defendants. However, the Commonwealth, just pulling away, guys, see, just right there, Miss Reed is not indigent. It's proving my point earlier. like, yes, she needs a defense fund because it's really freaking expensive to keep defending herself 2 years after John O'Keefe was murdered by someone inside 34 Fairview. It's really expensive, guys, to keep the tab going for a defense team like that. for 2 whole years. But she's not indigent, you know? And again, if she were, we likely would have never heard about this case. Continuing. However, the Commonwealth's actions have caused significant unnecessary travel expenses for her defense expert, Mr. Erickson, and thus for Miss Reed. Accordingly, Miss Reed now seeks to recover these travel costs from the Commonwealth, to order the Commonwealth to pay these fees in which this court's discretion and is in the interest of justice. Continuing. The interests of justice require the Commonwealth to bear the cost of having Miss Reed's expert travel out of state to the Canton Police Department to copy files which the Commonwealth knew had already been deleted, to force Miss Reed to pay the expenses out of pocket when she is already prejudiced by the loss of evidence itself would be a complete miscarriage of justice. Defense expert Mr. Erickson traveled to Massachusetts as part of an arrangement made between defense and the Commonwealth, in which the Commonwealth represented to the defense that Mr. Erickson could visit CPD and extract the relevant footage. At the time the Commonwealth made that representation, it knew or had reason to know via its agents who were responsible for properly preserving the footage but did not, and via Assistant District Attorney Lally and Special Assistant District Attorney Brennan, who did not take the actions necessary to ensure the evidence was preserved by those agents, that the footage was not properly preserved and thus was non-existent. Really good argument right there, guys. Just so solid. Continuing. The Commonwealth induced the defense expert to fly to Massachusetts anyway, wasting Mr. Erickson's and the defense's time and causing the defense great expense. Miss Reed should not be forced to shoulder this unnecessary financial burden. The travel expenses and other costs associated with Mr. Erickson's December 2024 trip to Massachusetts were incurred as a direct result of the Commonwealth's failure to meet its obligation of properly preserving material evidence. And pulling away from this, guys, what is it also saying? What is it also saying? Because according to this, it was Hank Brennan who okayed it. It was Hank Brennan who said they would coordinate with the Canton Police Department so that the expert, Mr. Erickson, could go through the DVR system. What is it saying that Hank Brennan and Adam Lally and Michael Morrissey didn't even give a damn? They didn't care enough to make sure that they had the original footage, that they had the footage that Mr. Erickson was going to evaluate. It's more playing dirty. It's more of Hank Brennan and Adam Lally playing dirty. Like, bring your expert over. Yeah, bring him over. Bring him over and waste your money, Miss Reed. We don't give a damn. Just left and right, you know, she's been mistreated and mishandled left and right by this prosecution. Continuing. This misrepresentation came at significant expense to Miss Reed, who paid in total $12,229 for these expert services and the related travel, because the Commonwealth arranged for the defense expert to travel to Massachusetts to inspect evidence that the Commonwealth had not properly preserved. It is in the interests of justice that Miss Reed be allowed to recover the related costs. I agree. You know, and if the prosecution doesn't want to pay for it because they don't want to look bad, you know, which, you know, most likely they're going to fight this, right? They don't want to look bad, even though they do. even though they already do, right? They don't want to have to pay for it. And if they don't pay for it, I'm going to call their bluff. I'm going to call bullshit, because again, they're willing to waste resources, waste time and resources and energy on a case they should have never brought against Karen Reed, but they don't want to pay for Mr. Erickson's fees for the cost of having him come over here because of something they said would be possible. Continuing. Conclusion. For the above reason, Miss Reed respectfully requests that this honorable court grant her motion to recover expert-related expenses related to defense expert Matthew Erickson's December 2024 trip to Massachusetts. Respectfully submitted for the defendant, Karen Reed, by her attorneys. And it reads Alan J. Jackson, Elizabeth S. Little, Worksman Jackson, and Quinn. And David Yannetti. And that's it. I don't see Alessi and certificate of service. So it was served to Hank Brennan via email by Elizabeth Little. All right. So it was dated January 22, 2025, but it wasn't available until yesterday, the 23rd. And that's the end of the document. And it provides the affidavit of Matthew Erickson as an attachment. If we want to read it, I guess I'll read it. It reads, I, Matthew Erickson, do hereby depose and state that the following is true to the best of my knowledge and belief. I am a computer, IT, and mobile device forensic analyst at USA Forensic LLC. I was retained as an expert witness by defendant Karen Reed in the above captioned matter for the purpose of analyzing the current DVR configuration and obtaining forensic video surveillance evidence from the Canton Police Department. Number 2, on December 11, 2024, I traveled from Phoenix, Arizona to Boston, Massachusetts by plane to render expert witness services in the above captioned matter. I stayed in a hotel for one night and returned to Phoenix by plane on December 12, 2024. The purpose of my trip was to allow me to extract surveillance video from the Canton Police Department's ExactQ Vision DVR system in a forensically sound manner, which aligns with methods accepted and commonly used in the digital forensic community, as well as review any video footage preserved within the system from January 29, 2022, between 12 a.m. and 11:59 p.m. I visited the Canton Police Department on December 12, 2024 to do so. Number 4, I arrived at CPD on the morning of December 12, 2024 to begin my review of the DVR system around 9 a.m. and was met by Colleen Crawford, who I was informed is a multimedia director and certified forensic video technician from the Norfolk District Attorney's Office, as well as 3 other individuals. Ms. Crawford expressed surprise that I was there to do this work. Relatedly, skepticism that the footage would still exist. I asked whether anyone had accessed the system to determine whether the relevant video footage was even present. They answered, quote, no, end quote. Notably, before I made this trip to Massachusetts, the defense team spoke with Miss Crawford and she was made aware of the footage the parties had agreed would be extracted by the defense, specifically relating to the accepted date and time parameters that would be used for these processes. So pulling away, guys, like already in his affidavit, he's saying, we had a clear plan before I even came. We were told this would be possible once I arrived. You know, we were told before I even left that this would all be possible, that I would be able to do my forensic analysis. Number 5, After photographing the relevant DVR equipment, I began recording audio and video and then accessed the system. Initially, it appeared that looks like a typo. It appeared that there were only 30 days of video history, and consequently, that the relevant footage had not been preserved. That impression was confirmed when I navigated to the appropriate section of the DVR system, where a search by date and time could be performed, and ran a search for January 29, 2022, 12 a.m. to 11:59 p.m. That search returned 0 results. Based on the size of the drives, the percentage used, and the remaining usable drive space, I concluded that there was mathematically no possible way for the videos from January 29, 2022 to be present in December of 2024 when I performed this search, unless they were manually saved and or properly preserved via standard forensic protocols. Number 6, next I began the process of generating my activity logs for the date of interest. This request ran for an abnormal amount of time without showing results. When asked whether the system had ever behaved this way and whether it could be expected to complete the request, the person on site who was most familiar with the system shrugged and said he didn't know. After investing approximately 10 minutes into this and similar actions with no results, I determined that the relevant activity logs were also gone. Number 7, while there, I asked the individuals whether they had done a forensic extraction of the drives to get the original data, to which they answered, quote, no, end quote. I asked how they preserved video when they needed to, and they responded that they simply manually saved the video from the DVR. Finally, I asked if they had a written protocol in January 2022 or now for saving video. They responded that they did not. No written protocol, guys. Confirmed by Mr. Erickson. Continuing. Number 8, the individuals refused to provide me with a copy of the original video files that they originally pulled from the DVR system, stating that the information had already been provided to defense counsel. When asked how they produced the footage to the court and or the defense, they seemed confused. I clarified by asking whether it was provided on a USB drive, disk, or share link. They could not tell me for sure, but eventually said it was probably a share link. I explained that getting a copy of the video files directly from them would help us ensure that we are working with the same hash-verified data that was disclosed to defense. They continued to advise that I get these files from defense and declined to provide me with any of the original video files. Number 9, the way CPD technicians extracted the video data from their DVR system is insufficient for forensic purposes and has resulted in the permanent loss of the original surveillance video data. The CPD DVR system, like most stores videos in a proprietary format. CPD uses the DVR interface to pick and choose which videos to save, and then that data is converted by the system into a playable format. The resulting file is almost always of lesser quality than the original, and because it exists in a different format, the resulting file will not hash verify to the original. As such, forensic experts cannot properly test the authenticity and integrity of the video footage. Number 10, due to the Commonwealth's failure to preserve the original surveillance footage, I was unable to extract the DVR system footage from January 29, 2022 to obtain relevant footage between 12 a.m. and 11:59 p.m. as previously arranged and agreed upon by all parties. Number 11, the plane fare in total cost $2,202.96. Number 12, the one-night hotel stay in total cost $233.77. Number 13, Uber trips to and from the airport's hotel and Canton Police Department in total cost $314.72. 14, other expenses, snacks and beverages at each airport and Wi-Fi on December 11, 2024. Flight to Massachusetts totaled $103.12. 15, the fee associated with the 10-hour December 11, 2024 travel day was $375 per hour, or $3,750 in total. Wow. Continuing. Number 16, the fee associated with the 15 hours of work performed at the Canton Police Department on December 12, 2024, and in Phoenix, both before and after the trip, was $375 per hour, or $5,625 in total. Number 17, in sum, the travel expenses, expert fees, and related costs associated with my December 11 to 12, 2024 trip to Massachusetts totaled $12,229.57. Signed and sworn to under the pains and penalties of perjury, this 22nd day of January 2025, Matthew Erickson. And that was the affidavit. All right, guys. So isn't that a quinky dinky also? Isn't it a coincidence that Ian Whiffen stood on the stand, right, telling us that he went through the cell phone extractions, but he not once verified those cell phone extractions using the hash values, right? So the prosecution didn't provide hash value verified cell phone extractions to Ian Whiffen, and the prosecution did not provide hash value verified video surveillance from the Canton Police Department to the expert Matthew Erickson. It's like what's the prosecution got against hash values? What does the prosecution have against hash values? Like, why does not the prosecution want the cell phone extractions to be verified? And why does not the prosecution want the video surveillance to be verified? Both using hash values, right? Coincidence or cover-up, guys? Thank you for being here, and thank you for watching.